Hey, Injustice in America, CJ3450. Hope you guys are doing well. We're moving into staying in chapter 6, but moving into the courts now from police. And just as when we did the police unit, I gave that video basically starting with the basics, I'll do the same with the courts, and I'll say essentially the same thing. A lot of the stuff that I'm going to start off with is like intro level to criminal justice stuff, or intro to courts type stuff. If you've had those classes, you'll be familiar with this. If not, Google it, pick up an intro book, whatever. But just to start with some of the basics first before we get into the main stuff in the book, you understand that what the courts do is basically take over where the police leave off. So at the point where someone's been arrested and they're being processed through the system, courts have three different phases. The first is the pretrial phase. That's everything before a trial, which includes whether you get bail or not, or whether you sit in jail, and what's called preventive detention. Preventive detention is you're being held for until your trial date, till your case is resolved, because either you're a flight risk, or they think you'll leave the jurisdiction, or you're considered a danger to the community based on your past record and or what you've been arrested for, and the degree of certainty they have that you did it based on the evidence they have. It also includes the charges that they press. Now, this is important because the innocent bias stuff can be seen in bail and in charges. So if you have disparities between blacks and whites, for example, in whether someone gets bail or if they're held in preventive detention, or some people might be charged more seriously than others, that would be indicative of an innocent bias potentially, or racial bias potentially, if it can't be explained away by legal factors. Okay, so that's the pretrial phase. The trial phase is called that even if there's not a trial. And as you'll see when you go through the notes in the book, about 95% of people accused of felonies don't even get a trial. They plead guilty. This raises another problem with criminal justice that we'll get into. And finally, the post-trial phase is everything after a trial. That's basically your sentence when you're sentenced by the judge, and also if any appeals that you file. So what you'll see is that there's problems at each of these phases that stem from what we've been talking about all semester as innocent bias. Okay, so we'll get into those, but before we move into those, I want to point out, if you look through the PowerPoint slideshow at the very beginning of the courts, you'll see that the largest portion of convictions in state courts and the largest number of convictions in federal courts, not a majority, but the largest number, are drug cases, about a third or so. Now, the question there is, what is the meaning? And that's up to you. My point, I'm bringing it up, is it a good use of resources to devote a third of all of our money, time, energy, etc., into drug cases, particularly now that states are starting to legalize drugs like marijuana? Seems to be the opposite direction that we're going, right? So maybe we could better use those resources for violent crimes, solving cold cases and things like that, going after white collar and corporate criminals that really harm us a lot, and then handling drug cases potentially in public health settings, drug courts, treatment facilities, and that sort of thing. Just something to think about going forward, something you guys will deal with in your life. Another key fact is that if you look at the typical client, that's what's next in the PowerPoint slideshow. About 80% of people in the courts are what are called indigent. And indigent is a legal term meaning you can't afford a private attorney. So you're talking about poor people in the courts. You're talking about the largest portion are male, African American, younger than 40. The same is true in the federal courts when you look at who's convicted of crimes. Males, people of color, and people younger than 40. So the other question is what's the meaning of this? And if you just compare who makes the law and who owns the media versus who gets processed through the courts, the only common characteristic is the male gender or sex. So in other words, people that make the law and own the media are rich old white men, which we called worms in class. And the people that suffer from the law the most in terms of who's in the courts and then who ultimately goes to corrections like prisons, they're young, minority, generally poor men. Isn't that interesting? It's consistent with what we said in the class. You would not expect the lawmakers and the media to focus the spotlight on themselves, and as a result, the people being caught, convicted, and sent to prison are not those people, as we talked about. Now, the next thing in your PowerPoint is the ideals of American courts. And here is sort of the theme of the class, right? We've been comparing the ideals, the way things are supposed to be, versus the way they really are. Ideally, courts will uphold due process. So everyone should have a trial. That's the process you are due as a person, as a citizen of the United States. Ideally, courts will be fair. Your constitutional protections will be, your constitutional rights will be protected. Courts will follow stare decisis, let the decision stand, or not violate precedent of a prior court or a higher court. And also, ideally, courts will balance the interests of defendants versus the government. Well, the more we're in a crime control model of criminal justice, the term we described earlier in the semester, the less concern we'll be with due process rights. So due process and fairness are threatened by a war on crime, a war on drugs, or on terrorism. It doesn't mean we totally abandon them. It just means that they're less important to us, or something else is more important, like public safety. By the way, we're seeing this to a degree, aren't we, with the current pandemic. And now you're starting to see some protests against the restrictions of our freedoms. Please do be aware, if you're paying attention to the news, that these protests are not spontaneous. They're not regular old folks rising up against the government. These are actually orchestrated and planned by some very powerful people. So Google that and fact check it and find out for yourself who they are. Nevertheless, you may have a legitimate concern about your rights being violated, freedom of movement, freedom of assembly, the right to vote, things like this, based on the government restricting our access during the pandemic. However, keep in mind, the purpose of these restrictions is in the interest of public safety, consistent with the crime control model, okay? Now, those ideals that I just mentioned, due process, fairness, etc., are threatened by contemporary court practices. And an example is the fact that 95% of people who are accused of felonies plead guilty. That is not due process. That is not a trial. That's just one example. Okay. The other thing that you'll see in the PowerPoint slideshow is there's a major imbalance of power in the courts. Think of a trial as, like a competition between the prosecutor and the defense attorney, where the prosecutor represents the interests of the people and public safety, and the defense attorney represents the interests of the defendant or the person charged with a crime. The judge is the neutral arbiter or the referee in this competition. And we like to think of this as a battle to find the truth, right? So the truth is all of these members, the prosecutor, the defense attorney, and the judge, are members of the courtroom work group, the main actors who work in the courts every day. And ideally, as I just mentioned, they each have their own goals and their own roles. However, in reality, they all have the same overriding goal. And that goal of the prosecutor and the defense attorney and the judge is to dispose of cases as quickly as possible. This gives the government the advantage in nearly every case, because think of it this way. If your defense attorney is most interested with getting rid of the case, that means they'll probably encourage you to plead guilty, which serves the interests of the government. And therefore, this is one of the main reasons why 95% of people accused of felonies plead guilty. Okay. Now, what drives plea bargaining is a large number of cases and the imbalance of power between the prosecutor and the defense attorney. The prosecutor has the money, the resources, the power, the staff, and therefore they determine the outcome of trials and how cases are disposed of for most people. Now, it has to be that way because the prosecutor has the burden of proof. You are innocent until proven guilty. But when it comes to plea bargaining, your defense attorney is basically assuming you're guilty, or else why would they be encouraging you to plead guilty? This is a big challenge for American criminal justice today. So this is something that you'll see discussed a little bit in Chapter 6 as well. All right, flipping through, the prosecutor has the power. You'll see later in the PowerPoint slideshow an example of how much money the prosecution gets in the United States versus how much money we spend to defend poor criminals or people who are alleged to commit crimes who tend to be poor. And you'll see We spend vastly more money to investigate crimes, arrest people, convict people than we do to defend them, which suggests we're more concerned with public safety, like the crime control model, as opposed to the due process model and the rights of individuals. Okay, so keep that in mind. Now I'm going to stop here. That's a quick introduction. The next video will be about the different phases of the trial, of the courts, I should say. This is pre-trial, trial, and post-trial, and the focus, I'm going to try to focus on the whole idea of innocent bias and how we see it in the courts as well. Bias that comes from the law and how that manifests itself in bail, charging, plea bargaining, convictions, sentencing, and stuff like that, okay? So you'll have 2 PowerPoint slideshows. One is sort of the introduction with all the different stages of the trial. The second one are of the stages of the courts. And the second one is actually focused just on the post-trial phase, which is sentencing. So be aware of that, okay? All right, more shortly. Keep well. See you in a few.